Good afternoon. Welcome to the next of our Essential series. These are topical and technical webinars focusing on the best of the private client world. The Juror Society brings women wealth holders and their advisors together through education, collaboration, and inspiration. Our private network, the Society, provides invitation-only access and knowledge to leaders in the private client and wellness industries. This afternoon, I'm delighted to welcome Laura Phillips, Legal Director at Kingsley Napley, who specialises in covers contentious trusts and estates and dealing with undue influence and vulnerable clients, including the applications to the Court of Protection relating to people lacking capacity. Over the next 20 minutes or so, we'll be taking part in a Q&A style discussion. Please note this is for education purposes only. And if you do have any questions, then please do ask them in the chat or feel free to reach out to myself or Laura afterwards. So just going to get Laura in now. Hello, good afternoon. How are you?
I'm good, thank you. How are you?
I'm all right, all things considering, nasty bug. Let's kick things off with who are you, what do you do, and who are your typical clients?
Sure. So my name is Laura Phillips. I'm a legal director and I specialise in contentious trust and estate disputes. It covers a broad range of all sorts of succession issues, but also I specialise in Court of Protection disputes. It's a slightly niche practice which covers people who lack capacity, so it sits in its own court jurisdiction, it has its own court rules, etc., and they will only act where somebody lacks capacity. So our usual client base is high net worth, ultra high net worth people who have family businesses and sort of things like that, where there may be succession disputes as to who takes charge when somebody lacks capacity, or succession disputes traditionally are when somebody passes away and there is a potential for a void of a bit of a power struggle. Everybody, I suspect, has seen or heard of the TV series Succession. I haven't seen it because it's a bit of a busman's holiday, but I'm led to believe that that's what all of that sort of covers. So it's that sort of area where there's will disputes and things like that.
Interesting. So why don't we just look at actually what is the definition of lacking capacity?
So there's two, unhelpfully perhaps in English law, there's two different definitions. And so if you are alive, the test of whether you have capacity is slightly different to when you've passed away and you have capacity to make a will. So you may have fluctuating capacity. The reason this is such a sort of key topic at the moment is because of dementia and increases in cognitive function things. So if you were to come to the Court of Protection, there is a Mental Capacity Act test as to whether somebody has capacity to make fact-specific decisions. So that might be ranging from I have capacity to decide where I want to live, what I want to have for breakfast, whether I want a cup of tea or not, all the way to do I have capacity to manage my property and financial affairs? Am I able to give someone the authority to access my bank accounts? Can I, etc., to sell my house? That sort of range. Whether someone has testamentary capacity is slightly different, and that is whether somebody has the capacity on that day to make a will, which really depends on an ability to retain information, weigh up that information, and also whether you can decide and have a knowledge of the fact that if you leave all of your assets to one child, that might cause a dispute with another child who gets left nothing. And so it's a slightly different test, unhelpfully perhaps, depending on what you're looking at.
Yeah, so that's a bit more of a game of consequences in a sense, being aware of the consequences of what...
Exactly. Are you aware that by giving your house outright to one of your children, that could cause significant divisions in the family? So it's having an awareness of what you're doing, consequences, exactly.
Fun. Cool. Thank you. So we know that there are disputes amongst families for a myriad of reasons, just on the day-to-day life, disputes happen. But what are some of the most common reasons succession disputes arise?
So I've touched on a couple of them. I think they've increased exponentially in the sort of 12 years I've been doing this, but really it's a pattern that goes back perhaps 20 or so years and continues to grow. There are, I suppose, several trends. So the most common trend these days is because of what we're calling blended families. So second, third, fourth marriages, where people might have children from other relationships. You're then introducing stepchildren. There is a preservation of wealth where one of the partners might come with a slightly different wealth position than the other, and then wants to preserve that position for their own children, which again can lead to disputes with stepchildren and things like that. So that's one issue. Multiculturalism. We don't have Sharia as such in this country. It's not legally applicable, but we have people who would like to apply Sharia principles to their estate planning. So people holding assets offshore. I don't mean sort of hiding it away in traditional offshore structures and trusts and things like that, but it is more and more common that people move around globally and so have bank accounts and properties and so on in other jurisdictions where the succession rules might be different. So France, for example, has different succession rules as to what you can and can't leave your children, or have to leave your children. So forced heirship rules. So it just brings about a sort of natural division in personalities and where things are. I suppose the other thing is the cost of living and the price of things. There is more in the pot to argue over, depressingly. So whereas a property may have been not worth very much 20 or 30 years ago, that is now, with property prices rising, you can suddenly see that a house that might have been bought 30, 40 years ago for £30,000 could now very easily be worth 600,000 or 700,000. And so really the merits of litigation and the cost of litigation, there is a certain element of having more to fight over, I suspect. So it all sorts of trends, but those are probably the key ones, as well as things like dementia increasing. We're all living a lot longer than we used to, things like that. So those are really where those sorts of fractions arise.
Brilliant. And I think, don't these claims fall under the Inheritance Provision for Family and Dependants Act 1975?
We tend to, if it helps, we abbreviate it to the 75 Act, generally speaking. So there's two different types of estate dispute generally, and the first is whether a will is valid. So if somebody leaves a will, that's almost a different question. And then you have a 1975 Act claim, and that is if you have to fall within a certain category of claimants. So traditionally, spouses, children, cohabitees can fall within that if you've been living with the deceased for 2 years before they pass away. If that category of claimant feels that they haven't been left a, inverted commas, reasonable financial provision, then they can make an application to the court for a bigger chunk of an estate. There's lots of factors to it, but generally that works whether you have a will, which has to be valid because otherwise it's a slightly different claim, but also under the intestacy rules. So if somebody dies without a will, there's a very strict line of who gets what under the rules of intestacy, and that is not always reflective of the family situation when you pass away. There is no such thing as a common law wife or anything like that. It's a bit of a misnomer, and so you can make an application under the 75 Act for more of the pot, and then in deciding whether that's reasonable, the court looks at lots of different things and factors, and weighs all that up to decide whether you should have more than you've been left.
Interesting. And then I think that rolls very nicely into medical assessments, determining capacity, because it's all well and good accusing, say you've fallen out with your sibling or your your father or someone, and you're like, okay, well, you lack capacity or something, trying to claim that they are not mentally sound. But actually, it's not just on someone's opinion. There is actually a process, isn't there, for going through this?
I mean, it's very difficult, I think, in terms of, because we say that dementia is not an outright bar. So if somebody has dementia or some sort of cognitive impact on their decision making, that can either be permanent, or it can be fluctuating, and maybe somebody is in a coma and so they lose capacity for that period, but there is a chance that they will recover capacity. Similarly, once you have a diagnosis of something like dementia, it's not an instant, somebody doesn't just lose capacity overnight, and so it can be quite difficult to pin down exactly when somebody loses capacity. And if a will is made in or around the time that happens, it comes down to quite a forensic examination of the documents. Now, that can happen because you can request the medical records, so you can have a look at, you can draw patterns from behaviour. We can look into the drugs that somebody is being prescribed to see how quickly somebody is progressing. But sometimes there just isn't that body of evidence, and there isn't that evidence when the will is made. And so it comes down to medical assessments, and you can get a retrospective medical assessment. And if there is going to be a dispute about whether somebody had capacity around that time, then really the next step is to engage a specialist, generally an old age psychologist or a psychiatrist, who goes back over basically looks at the same documents we do, but with a medical head on, and then can draw conclusions of the balance of possibilities and probabilities. Did they lack capacity at the time? And if they did, then the will be invalid.
That's really interesting. And I think as well, you mentioned earlier about cohabitating partners. Is there scope for them to claim then if they're left out of an estate?
It's really difficult with cohabiting partners. So the modern society has moved on faster than the law, which is not necessarily unusual. But so under the intestacy rules, cohabiting partners don't receive anything. We've talked about the strict sort of delineation of estates, and as a spouse you would obviously get a set proportion, and then children, parents, uncles, aunts, cousins, brothers, etc. Nothing for cohabitees. And so you could find yourself in a position where you've been in a relationship for decades potentially, and you have children together, and you've split your financial pot. You may have even given up work and stayed at home to raise the family, and then you're left with nothing under intestacy. And quite often, unfortunately, it's the case that when you're in your 20s, 30s, 40s, you're not automatically thinking, we must go and make our wills. It's just not even on your radar. And so I have friends who have been together for 20 years, but if he'd have passed away, she would have been in a very, very difficult situation. And of course, in those situations, you can make it, actually, that's where the 1975 Act is helpful. Because as somebody who has been cohabiting with someone for 2 years immediately before their death, you count as one of those categories. And it's quite usual that the court would say, you're right, the intestacy provisions aren't sufficient, and so they will make an allowance. But litigation is really slow, or it can be very slow. And so you find yourself in a situation where you're obviously grieving the loss of your partner immediately. And you could find yourself without access to bank accounts. None of the bills can be paid. The mortgage is accruing interest and you can't pay it. And then you have to bring a claim. Now, it can be resolved quite quickly, but that would be months rather than, immediately when you need the funds. So there is a provision, but it has quite a deep impact on cohabiting partners who are naturally trying to grieve, as you would expect, but also trying to navigate this horrible situation where you don't have any access to funds, at least in the short term. And quite often... Sorry, no.
No, I was going to say, so would having a will just make that all a lot easier?
It would make it a lot easier. Yeah, I think as I know, it's always the last priority, and as lawyers, it would probably astonish people to know that we're often the worst in getting it done, because we're always advising other people to go and get it done instead. But yeah, a will, even if you look at the will and go, do you know what, it's not reflective. It was made at a time when perhaps we didn't have children, so we got married and we made wills, but now we have children. And so even if your situation changes, you should keep it updated. It should be a living document, effectively. But a lot of people don't do that. But having something in place is better than having nothing. And a lot of people, when they're just starting out and they get married, I suspect the will would really replicate what the terms of the intestacy rules say anyway, because they would say, well, I'd only leave it to my husband anyway, so there's no point. That's fine, but also, it's longer term thinking than that.
Yeah, and also, if you've got funny chattels or different elements and a blended family situation as well, it is quite important to document what your intentions are for when you're not around. People
Absolutely. And
try not to think about that.
Exactly. And if you've got stepchildren, unless they have to be treated as children of the family. And so blended families can often, again, make that a bit more complicated with sort of the lineage, if you want to use that sort of term, and to where things go. And so, yeah, it's always a good idea to set those intentions out somewhere.
So would stepchildren have a claim on something potentially?
If they are, if they are being treated as a child of the family, i.e. they live with their parents and step parents and their school fees are being paid or something like that, then yes, they will have a claim. If they are an adult stepchild that's never been financially provided for, it would be a lot more difficult to get through in that.
Okay, that's helpful to know. Thank you. And then talking about that, what happens to someone if they feel they were not left a reasonable financial provision in someone's will? So, I think there's lots of horror stories out there about someone surprised being left out of a will or something like that, and they're like, oh gosh. What happens in those sort of circumstances?
That sort of typical Hollywood style where they go to the will reading and find that they've been totally disinherited. So when you get within that category of claimants, if you haven't been left anything, is the will valid or not, is your first sort of, because if the will is not valid, that's a different claim and you would have to challenge the will, and then you'd have to look back at previous wills and things like that. So that's really your first thing. If, let's say, there is a will and you just don't like it, or you don't think it is fair, or it replicates what you've been told, etc., then as long as you fall within the claimant category, you need to consider whether you've been left a reasonable financial provision. Is a fairly non-specific term, and it probably won't surprise you to know that some claimants feel that reasonable financial provision is a lot different to what the defendants to those claims do. So the court then have a look at what we call Section 3 factors. And it's basically a list of everything the court will take into account when it's deciding what's reasonable. They all have equal weight, although some of them will be more applicable in certain circumstances. So what we're talking about is the reasonable the resources and needs of the applicant, and that can include housing needs, medical needs, that sort of remit. If there's any other applicants, the same applies to them. The court will also think about beneficiaries. So obviously somebody has testamentary freedom in England to leave their estate to whoever they want. And there could be a perfectly explainable reason why they want to disinherit one child or why they want to give more to someone. And so in those circumstances, the beneficiaries of the will would probably take a role in proceedings and say, well, hang on a minute, these are my needs and this is what mum, dad wanted. They're going to look at the size of the estate. So, is this a multi-million-pound estate that could probably give a bit more to this person without really impacting anyone? Or are we talking about a pot that's going to be extinguished by the claim completely? Physical and mental disabilities on the applicant. So if one applicant has more future needs as well are taken into account. So if you have medical needs now, that can include therapy costs and things like that. So any sort of medical needs, whether you need to make adaptations to your house, etc. And then the court very helpfully sets out and anything else that may be relevant. So that usually turns on conduct. If there's been a massive falling out between testator and child and they don't speak anymore, that's really a conduct issue. Whether one child has given up their job or a career to care for a parent, and so they need financially more because they've effectively given up all their income. So all of those are thought about and weighed up, and it's quite a blunt tool because the people will have to give up all their bank statements. There's full financial disclosure. It's fairly sort of cards on the table, and it can be quite impersonal and fairly insensitive because it's a bit of a blunt, like, well, you don't need this much money to do this. So it can be a bit like that. But then weighing up all of that, the court will say, you're right, you are a claimant. You haven't been left financial provision. We've taken all of this into account and we will award you this. And it doesn't necessarily mean a lump sum of cash. It's not a blank check. It's sometimes the court might feel that your financial needs could be met by giving you, sounds very blasé, but giving you a house, or providing for your accommodation, or paying for your children's school fees until they're 18 or something like that. So it has a huge range of discretion as to what it can award under that.
And then who would be the person, or would that then be a trustee, depending on the size of the estate? Like, who would then be managing the court order in that sense
it can be a trustee. Yeah, so effectively the court order is made, and that is the provision, and then the executor of the estate, who won't take part in it, they will be neutral in any proceedings generally. They will make arrangements to either transfer the cash or transfer property, or if it's a minor, if it's an unborn or a minor child under 18, then there's usually a trust set up, and it will be up to sort of, is the parent the proper person to be the trustee? Maybe depending on the conduct issues which may have arisen. Sometimes grandparents can bypass children completely and leave to grandchildren, which can be a bit controversial, because they don't necessarily trust the children. So we have quite a lot of inquiries about parents who don't trust the person that you're marrying, that their children are marrying. And so there is a lot that goes into discretionary trust, and is then managed by trustees, so that there is a certain element of control over the funds, so that it's not just being completely squandered by whoever the deceased doesn't want to get their hands on it.
Gosh, it's fascinating, isn't it? The workings of families.
Yeah, they're great.
Thank you. Okay, I think you mentioned about statutory wills. Can you explain the process of applying for one through the Court of Protection?
Yeah, so as discussed, the Court of Protection only gets involved when somebody is living, and when they don't have capacity anymore. So this is a slightly different area where you can potentially have a probate dispute, which would take place after death, challenging the validity of the will, but when somebody is alive. And you can go to the Court of Protection in certain situations and ask them to make or remake a will while someone is still alive, on the basis that if they had capacity, they would definitely be changing their will or remaking it. There's certain situations where that is slightly less controversial. So if somebody has an intestacy situation because they haven't made a will, and then they lose capacity, and they're not married, or the division of assets is going to go somewhere under the intestacy rules that doesn't naturally fit, then you can ask the Court of Protection to make a will so that it avoids the 1975 Act claim. So children or partners, etc., are going to get sick. So that's one way of doing it. The other is if the situation has changed. So if somebody made a will 20 years ago and the landscape looks very different now than it did, they either don't own the assets that they did at that point, or they own assets now that they didn't at that point, etc., then you can ask the court to make a statutory will that changes the provisions, etc. You can also get involved in litigation where you don't think that the will is reflective of P. So protected parties in the Court of Protection, the person that likes to come, we refer to as P. So if it doesn't reflect P's wishes, then you can ask the Court of Protection to change the statutory will. That is quite contentious, because you can get involved in a situation where P almost imposes what they think P would like to do, rather than taking a step back and going, actually, is this what P would like to do? Do they want to leave their estates to this? But so the court, it really has to consider the application. They have to consider P's past and present wishes, and P will always have a role in Court of Protection applications. And that may seem a bit strange if you're saying that P doesn't have capacity, but fluctuating capacity means that they may have they might not have capacity to make a will because they can't retain the information, but they might have very, very strong feelings still about who they do want to benefit and who they don't want to benefit. And so you will get an independent visitor, somebody who specialises in this, a sort of medical professional, to go along and speak to P. And it could be in very, very basic terms. And then there will be a report that says P has no idea really what the will says, or doesn't really understand what a will does, but absolutely adamantly knows that they don't want this person, they don't like this person, they don't want this person to benefit, etc. And so the court, it's not contentious one party against the other. The court will take a step back and pull in all of the people who might have an impact on that, and look at all of the contemporaneous records, etc., and then come to a decision about whether a statutory will is in the best interests of P.
That's really helpful, and that's actually quite reassuring to know as well, that actually they are safeguarded in that sense, and they have a robust process to go through that. And that actually touches on really nicely on our final question, which is about financial abuse. We can't talk about vulnerable clients without financial abuse, sadly. And so what are some of the red flags that professionals should be aware of in potential financial abuse cases?
Yeah, there's some really scary statistics that came out not that long ago that suggests that, I've got it, 1 in 15 adults aged over 60 will experience financial abuse annually, which is just terrifying. And in England, so if you have a power of attorney, obviously for the most part, powers of attorney are very sensible, and they give somebody the ability to manage your property and affairs when you can't do that, or you don't have capacity to do that. Slightly scarily, 25% of people in England and Wales think that if you financially gain from a power of attorney, that's not abuse. And so if they're making out gifts to themselves, a quarter of people who have an attorney position don't think that that's financially abusing someone. So it's an absolute growth area, and it's quite terrifying. So STEP think that private wealth advisors and trusted advisors and things like that are in a better position to spot that. And so red flags, things like unexplained or unusual gifts, large quantities of money going out, perhaps mum or dad gifts a house to one of the siblings outright with absolutely no sort of conversation with anybody else. If you've been a trusted advisor or a financial advisor and you've always advised someone, and you notice somebody going slightly off-piste with their investment decisions, or all of a sudden saying, oh, well, I don't really know, but so-and-so knows, and they've told me that this is a really good idea, and so I'm happy for them to do it. That can be another sort of flag. More obvious ones are where you have people who aren't necessarily close relations moving into somebody's house, and sort of under the guise of caring for them, and within a very, relatively speaking, a very short period of time, people are off to solicitors and are making wills, or are asking for bank cards and bank access and stuff, and saying, well, I am now I'm caring for this person, and it makes sense for me to have access to the bank account so that I can pull out cash. Anything sudden or abrupt changes in financial behavior. Also, if a person, unfortunately, this affects people who are naturally slightly more vulnerable. So we've all seen the online frauds and the people who, give large financial donations to people who claim to be Brad Pitt or whatever it might be. And so anything that just feels a bit odd cannot, and sometimes there's an absolutely perfectly rational explanation. And an attorney who's acting in the best interest, or somebody who's acting, should be able to explain that and document that, and act in a conflict-free way, and say, well, this is, mum always gave us this much money for birthday presents, or she always paid for us to go on holiday, and here's the evidence of that, rather than she's just decided to treat us all to a week in Disneyland or whatever it might be, which could potentially be absolutely fine, but might feel a little bit out of character for the person that you're dealing with. So they're all red flags, which necessarily doesn't help, but it's just things to be alive to.
Yeah, no, that's super, super helpful. Thank you so much, Laura. Before we wrap up, could you give us one top thing that somebody can do today to alleviate any of the stresses that we have discussed in this conversation?
Gosh, I think just having, and this is very much easier said than done, having an open dialogue with somebody is critical. because a lot of the cases that we come across are where there has been no communication. Nobody likes to talk about death or what happens when somebody dies, and that's an awkward conversation. I usually raise it with my parents after a glass of wine, and it makes it a lot easier. And actually, if you can have those conversations earlier on, it can cut down on a lot of these problems and issues post-death. But it's about getting those strategies lined up before you get to that stage.
Yeah, easier said than done. Maybe, yeah, a little bit of wine might make it a little smoother. Well, thank you to everybody who has tuned in, anybody who's watching this on the replay. If anything has popped up that you would like to discuss, feel free to reach out to Laura or myself. And thank you very much, Laura, for joining us this afternoon.
Thank you for having me.
Thank you. See you soon. Bye-bye.